So good morning everyone, my name is Lalit Soni and you are watching Drishti IAS. In this live session, we will be discussing Indian Express of 17th of May, that is today. So let's start. We'll start with the practice question and then we will discuss 3 important articles. After that, we will move towards the around the world section. There we will be discussing 2 or 3 more articles over there, and then there will be one article for your own read, and then we will end up with a practice question. So today we will be discussing acquisition of private property. So in this particular case, when we are talking about the private property, you know that it is not a fundamental right to acquire a property, but it is a legal right, okay, or you can say constitution right, because it is mentioned in the constitution. Now the thing is, Supreme Court is telling you something about this, and they are saying that there are 7 elements. When we are talking about this particular right, there are 7 elements which has to be followed, and there are certain things which has to be done before you are acquiring any kind of private property. Herein we are talking about, let's say government is acquiring a private property. In that case, there are certain things government has to follow, there are certain duties government has to fulfill, okay. So we will talk about that. Then second is arrest in PMLA after cognizance. Now the thing is, let's say there was this case wherein a person was, you can say the case was filed against a person under PMLA, that is Prevention of Money Laundering Act, and then the magistrate has taken the cognizance of the matter, okay, but the arrest yet is not been done, okay. So after the cognizance has been taken by the magistrate, cognizance means that notice of the case, okay. Now after the cognizance has been taken by the magistrate, then ED, when we are talking about the cases of PMLA, ED is the investigating body. So ED cannot go for arrest, okay. There is other way, you can call the person, there is a summon, there is warrant, etc. But till then you cannot go for arrest once the cognizance has been taken. We will talk about that particular article as well. Then draft digital competition bill, okay. Now government has come up with this particular draft and they have asked for the public opinion. Today is the last date for that public opinion seeking. So if you want to give your opinion, you can do that. So this is about digital competition bill. We will be talking about this bill, we will talk about the provisions of the bill, okay, and we will see what are the concerns of the big companies with respect to this particular bill, okay. This is the front page of the newspaper. Here much of this is not important for us. This particular, you can say, a new era announcement by Putin and Xi Jinping. So we will talk about that in our around the world section. And then when we are talking about this article here, ED can't make PMLA arrest after the cognizance has been taken. Need court's nod, okay. So before any kind of arrest, you have to go for permission from the court, okay. So we will discuss this article, and then there is this gap closes. Overall turnout in the first 4 phases is 66.95%, okay. So here when we are talking about the turnout, we will not go into the phase wise details of the turnout. We will wait for the election to end, then after that we will be seeing that what was the overall turnout in the total phases of the elections, okay. So right now this article won't be important for us. We will be focusing on this article and this article, okay. Now let's start with the practice question. Which of the following is in the context of which the term qubit is mentioned, okay. The term qubit, it is you can say major when we are talking about computers, digital computers. You know that these are binary in nature, either there will be 0 or there will be 1. So these are called bits, okay. But the thing is, when we are talking about qubit, when in the case of quantum computers, the measures will be qubits, okay. A qubit means that it can be 0, it can be 1, or both at a time, okay. So there can be imposition, there can be entanglement. All these things are not important for you right now. Just know that qubit is a measure when we are talking about the quantum computing or the quantum computers, okay. Option B would be your right answer here. Now let's start with the first article of the day, that is related to your acquisition of private property not valid if proper procedure is not followed. That is what Supreme Court has said. Now the thing is, what is proper procedure? Now court has said that when we are talking about the acquisition of private property by government, there are certain things you have to do. You have to give a notice to that particular person that their property might get acquired. You have to give a particular compensation. You have to get a nod from that person. All these things are to be done, and if you are not doing it, that acquisition will be invalid, okay. So that is what Supreme Court has said. So let's see. The procedure prescribed for the acquiring private property is part of the right to property under Article 300A. Now you will tell me under which constitutional amendment act the right to property, was taken out of the fundamental rights and then put into another right under the constitution, that is your 300A, article 300A. Now this is a, you can say, constitutional right, okay, but not a fundamental right, okay. Now here you can see, so right to property, the procedure prescribed for the acquisition of the private property is part of right to property under article 300A of the constitution. Any acquisition done without following the proper procedure will be considered outside the authority of law. That means that if you are not following the procedure, that will be invalid, okay. Now there are 7 basic procedural right under article 300A confers on the landowner which need to be complied with before a valid acquisition. So there are 7 rights here, they are given, okay. That is right to notice. So state has a duty to inform the person that they are intending to acquire their property. So that is the one thing that state has to tell you, that we are intending to acquire this particular property. So that is basically a right to notice. Second is right to be heard. When you have provided the notice, now the owner has right to be heard, okay. So you basically have to hear their objections as well, okay. So here duty to hear the objection to acquisition, that is right to be heard. Third right is right to a reasoned decision, okay. Now after you have informed, now that person has a right to arrive at a particular decision on the basis of their own rationality, okay. Duty to inform the person of its decision to acquire, okay. Then next is acquisition only for the public purpose. Government can occupy your property or acquire your property only in the case of public purpose, okay. So here it is that the duty to demonstrate that the acquisition is for the public purpose. Now you have this duty, government has this duty to tell this owner that this is the purpose for which we are acquiring your land, and that purpose is basically for the betterment of the people, okay. So that is another one. Next is right to fair compensation. When you are taking their property, you have to compensate for that. Next is right to an efficient conduct, okay. So duty to conduct the process of acquisition efficiently and within the prescribed timelines of the proceedings, okay. So that is efficient, and in the timely manner you have to conduct the acquisition. Now right of conclusion, the final conclusion of the proceedings leading to the vesting, okay. So herein in the concluding, when we are talking about right to conclusion, there will be the rights will be transferred over there. So that is about the 7, you can say, basic procedural rights which are mentioned in article 300A, which is the constitutional right, okay. That is about your right to property. Now these 7 steps may be procedures, but they do constitute the real content of the right to property under article 300A. So basically they are saying that these are procedures, no doubt, but that is the real intent behind it. Even in case of acquisition, the acquisition will be you can say following a particular procedure, so that your rights are not curtailed, or you can say that there is no invalid acquisition that has happened, okay. So that is why these 7 procedures are given, and as a matter of fact you can see them as a part of the right to property, okay. Non-compliance of these procedures will amount to violation of the right. Obviously, if there is a right, okay, which is given to you by the constitution, and if government is not fulfilling that particular right, ultimately that will lead to a violation, okay. Now the ruling said that the requirement of the law does not end with the mere presence of the legislation which empowers the state to deprive a person from his property. Here they are saying that when we are talking about the existence of a law, the thing is, if there is a law which says that you can acquire the property, this does not mean that you can that is the you can say that is final, or you can say without any kind of reasonable restriction on that. Here what is the reasonable restriction? That restriction is that you have to follow these particular things, you cannot deny these rights, okay. So these are 7 things which you have to be done. So here you can say requirement of the law does not end with the mere presence of the legislation which empowers the state to deprive a person from the property, okay. When we are talking about, we say that procedure established by law, okay. That means that for doing anything, or for government to do anything, for executive to do anything, there should be a law, okay. If there is a law, then government or the executive can do that, okay. So that is the procedure established by law. But when we are talking about India, we have a particular you can say a very optimum mix of procedure established by law and due process of law. That means that if there is a law, you can go for the, you can say deprivation, or you can say you can go for the acquisition of the property and deprive the person from their property rights. Okay, but the thing is that particular law should also have a due process. Due process means all these requirements has to be fulfilled, and if you are not doing that, ultimately that will lead into the violation of that particular thing, and ultimately this particular you can say property acquisition will not be valid. Okay, so here rather the nature, characteristics, provisions and the procedure provided in such legislation must be considered. So ultimately you have to follow the procedure. The state must mandatorily comply with the procedure which has been provided under the statute of the for the acquisition to be valid under Article 300A. The existence and the adherence of the procedural safeguard is crucial for the protection of the right to property, as they ensure fairness, transparency, natural justice and non-arbitrariness, or you can say non-arbitrary exercise of power. Okay, so that is basically your idea behind the Article 300A. Okay, what is the case right now? So there is this particular case in Kolkata Municipal Corporation that there was this person, his name was Biranchi Bihari Shah. They tried to take the property of that particular person, and with respect to that he has gone to the court, and now this matter has been in front of the court, and court has said that in case when you are acquiring the property, you have to follow all these 7 duties. Okay, so I hope this is clear. So that is all about this article. So question is, sir, what is acquisition? Acquisition means that, let's say, I'll give you an example for your better understanding. Let's say you have a property over here, that is your property, and let's say there is this government property over here, and now there is this is government property and this is private property. Now there is a road which has to be passed from this particular area, and that road is, let's say, some 80-meter road or something like that, and then this whole portion is to be covered under the road. Now this portion over here, that is a private property, and now government has to acquire this property so that that road can pass through this. Okay, that is the public purpose. So taking this property of this private person, that is acquisition of the property. Okay, so that is basically acquisition. Now moving further, next article which is related to your ED can't make PMLA arrest after cognizance, needs court's note. Okay, so here simple, in very simple language, because there are certain technical words which we will be talking about, but in the very simple language what I can tell you is that whenever there is a case which has been filed under the PMLA, okay, there are certain procedures, and PMLA or the offense, they are cognizable offenses. Okay, so when something like that happened, so magistrate has to take the cognizance of the matter. Okay, so cognizance means that magistrate has taken the notice of the matter, and then investigation will start. Okay, so in such cases, if arrest has been made, that is fine. Okay, but because arrest has been made, magistrate has taken the cognizance, magistrate might even go for the bail, etc. But the thing is, if arrest has not been made, magistrate has taken the cognizance, and now ED is going for the arrest of a person, that cannot happen until unless court provides for it. Okay, so in simple words you can say magistrate afterwards will decide for ED to go for arrest or not. There are, because when we are talking about the cases like PMLA, UPA, etc., once arrest has been made, going for bail is a hideous task, because these are the kind of serious offenses. For that, bail provisions has been kept quite strict. Okay, so that is why here Supreme Court has said that since the bail provisions are strict, in such cases, if you have not gone for the arrest and magistrate has taken the cognizance, so afterwards you cannot go for the arrest until unless magistrate says that. Okay, so let's see here. Enforcement Directorate cannot directly arrest a person under the Prevention of Money Laundering Act PMLA once a special court takes the cognizance of the complaint, and agency will have to approach the court if they want the custody of a person. Okay, so they are saying that once the cognizance of complaint has been taken, the notice of the complaint has been taken, afterwards if you want that person in your custody, you have to go to the court, take a permission from the court, and then you can arrest him. Otherwise you cannot arrest that person. Okay, so that is in the simple language, it is written over here. Here you can see, after the cognizance is taken of the offence punishable under the section 4 of the Prevention of Money Laundering Act, that is PMLA, based on the complaint under section 44 of the ED and its officer are powerless to exercise power under section 19 to arrest a person shown as the accused in the complaint. Okay, so here they are saying that once the complaint has been filed under section 4, in that case ED and their officer cannot go for the arrest. Okay. So if the ED wants custody of accused who appears after the service of summon for the conducting the further investigation in the same offence, ED will have to seek custody of the accused by applying to the special court. Now complaint has been filed, cognizance has been taken. Now there will be a summon which will be issued by the court. Summon means that you are sending a notice for that person to call. Okay, so basically summon is a legal document which will go to that person and says that you are accused in this particular case and court is requiring your presence on that particular date. Now that person will come, and if ED wants the custody of that person, then they have to ask the court for the that particular thing. They directly cannot go for the arrest. Okay, so that is the whole matter. Now we will see what is the technicalities over here. The Supreme Court ruled that once the special court take cognizance of a complaint under the Prevention of Money Laundering Act, the enforcement director cannot go for the arrest of such person. Okay, that is simple. Here you can say this is the same thing. Supreme Court court's ruling extend protection against the arrest by ED when an accused is actively participating in the investigation without being evasive. The relief is significant as the bar on the granting bail once arrested is very high in the ED. When we are talking about this particular thing, why this matter is important for us, because let's say the cognizance has been taken and that accused is coming on the summons, on the investigation, he is cooperating. So in that case, and he is not running away from the country, in that case going for arrest will not be a good idea, because when we are talking about the arrest in the ED or PMLA related cases, the bar is so high that bail might not be granted. Okay, so that is why this is a kind of protection which has been given by Supreme Court to the accused in this particular cases. Okay. So that is about it. And now we will see further. If the accused appears before the special court after receiving a summon, they don't need to apply for bail immediately. So basically they are saying that if court has sent the summon and that person comes to the court, and then he does not have to go for the applying the bail immediately, because they will not consider the arrest until unless ED asks for it and court says that okay fine, you can take the custody. Okay, till then you don't have to go for the bail immediately. Then instead of the bail, the court may ask the accused to furnish a bond as per the CRBC. Okay, so instead of bail they can take a bond. Bond means that will be a kind of a surety that whenever we will ask you for the investigation, you will come. Okay, so that is something, or bond will be signed by the court instead of bail, because bail is a tedious process in that PMLA. If ED needs to investigate further on the same offence, they can arrest someone not previously accused, but they must file certain requirements. Okay, so basically here they are saying that in case if they need custody of a person, they can file some requirements, and after that they can go for it by the permission of the court. The court should issue a summon instead of a warrant if accused was not arrested before. Even if the accused is on the bail, summons should be issued. So basically they are saying that if accused is not arrested, or if he was arrested and he was on a bail, then you can go for the summon and not for the arrest again. Okay, you will send the summon, and if they come, that is fine. Otherwise you can go for a warrant and then there will be an arrest. Okay, again, the court can exempt the accused from the appearing in the certain cases if they provide a valid reason. If the accused does not appear despite a summon, court can issue a warrant stating with a bailable one. Okay, so basically what they are saying, that first, that after the cognizance, what will happen, that you can go for a summon. If they are coming by the summon, that is fine. Then if not, then you can go for a warrant, and now this warrant will be bailable first. Okay, that will be a bailable warrant. Okay, and in that case also, if they are not coming, then further we will see. Accepting a bond from the accused does not mean granting bail. It's just an assurance that the accused will show up in the court. Okay, then if a warrant is issued due to a non-appearance, the court can cancel it and the accused does not need to apply for a bail again. Okay, so all these things are basically some technical things. You don't have to remember all these things. This ruling gives a protection against the arrest by the ED. As I told you, if the person is cooperating in the investigation, then if it's significant, because getting bail in ED cases is usually tough. Okay, so this is the procedure. If cognizance has been taken, then there will be no arrest by the ED until unless court provides for it, and court will first go for the summon, and if on the summon person comes, that is fine. If not, then you can go for the warrant. Okay, on the summon, let's say person comes and you can go for a bond. You can sign a bond with the person, and that on the basis of the bond you can say that it is a surety that that person will cooperate with you. They will come to the court or the investigation authority as and well required. Okay, and then if the person is not coming by the summon, then you can go for the warrant. That first there will be a bailable warrant, and then if not, then you can go for a non-bailable warrant. Okay, so that is about this article. Now we can move further to the next one. Hold on. Digital draft competition bill. Why big tech companies are basically opposing it. Okay, so with the name it is clear that digital competition in the digital market. Okay, so there are companies like Google, Apple, Facebook, Meta, WhatsApp. All these companies are big tech you can tech giant. So there are chances that they will have an undue advantage in the business as well, and which is like you can say present in some cases. So when we are talking about the normal course of trade, we have Competition Commission of India, and we have a Competition Act as well. Okay, then when we are talking about this digital protection, digital monopoly etc., then there is this particular bill which has been drafted, that is Digital Competition Bill. Okay, now here you can see the last date for public comments on the digital draft Digital Competition Bill 2024 passed on Wednesday. Okay, here you can see the bill contains provision which could stop tech giants from self-preferencing their own services and using data gathered from one company to benefit the other company. So there are two provisions which we will be talking about. One is your self-preferencing. Self-preferencing, by name it is clear that they will prefer their own products first. Okay, that is self-preferencing. Then second is using the data for the betterment of the other companies. So let's say there is this one company, let's talk about Zomato. Okay, so this is the company, they are gathering the data, and if they are using that data to help out some other company, so that is also one thing that can happen. But the thing is, because of which there should not be an undue advantage, and to regulate all such things, this particular bill has been placed. And again I am telling you, this these things are just example. Okay, then it also set presumptive norms to curb the anti-competitive practices before they actually take place, with a heavy penalty to the tune of billions of dollars for violations. So basically they are saying that presumptive norms means that generally what happens, that if a company goes for some kind of undue influence or some kind of unfair activity, after that there will be action which has been taken by that particular authority, let's say Competition Commission of India. In case of any undue practice or unfair practice has been done in the course of business, Competition Commission of India will take action, but that will happen after that particular crime or the offense has happened. Okay, so that is one thing. After that they will take the you can say action. But the thing is that cause of action has already happened, market has been influenced by that particular decision. Okay, and the benefit might have been gone to the company by then. Okay, and afterwards you are going for action on that particular company. Okay, right now in this particular act, what they are doing is they are making a presumption that companies can do that. Okay, so they have made a provision beforehand that if some company is trying to do that, they should not do it, because there are violation rights. Okay, there are violations, there are some fine which has been of the very high you can say tune, that is of billions of dollars. So that is a presumption that they have taken, that companies might go for the competition or undue or you can say unfair means, and that is why they have incorporated few provisions in that. Okay, so that is based on a presumptive norm. Now key provisions, let's talk about that. Predictive regulations, predictive or presumptive regulation, as I told you earlier, what used to happen, that ex post facto, like something has happened and afterwards you will take action. Okay, so earlier, as I told you, in the normal or the traditional markets, what happens, that if someone performs some activity and that is unfair means by that is somehow unfair to the other partners or you can say other players in the field, in that case you can go for the action, but that issue has already been done, the profit has already been generated and they have been utilizing it. Okay, but right now in this particular case it will be an ex ante. Ex ante means that before it happens we will be taking you can say precautionary measure in this particular case. An ex ante framework will be made over here, okay, foresees potential harms that can arise out of antitrust issues and prescribe predetermined no-go areas. Okay, so basically they have said that they have already considered certain you can say potential harms. They have already created certain areas that there are these provisions in these areas these companies should not enter. Okay, so that is your basically predictive regulation. Okay, so there are no-go areas which already has been decided due to the complex world of the digital markets, which are ever growing with increasing interlinkages between the various offering made by the single company. A forward looking and preventive and presumptive law is crucial to the anti-competitive practices in the space. So basically here they are saying that such law was necessary because since this technology is growing very fast pace, so that is why there are chances that these there can be a competition which we might not realize. Okay, so let's say I'll take this one example. When we are talking about let's say Google search, okay, there is a search engine that is Google, and you will go on that, then you can put certain input over there. First thing you will see is that there are certain you can say results which are related to their own sister companies, or you can say like YouTube, etc. So you will find out that these things are coming at the top. So that is basically something you can say a competition. They are trying to influence the audience over here. So such things can happen and we might not even realize that. Okay, so for that they have gone for the predictive regulations. Before something happens they have actually regulated for that. Okay, so that is in simple words the meaning is that before these practices happen, before the competition starts, before something unfair happens, they have gone for the regulation of that particular thing. Okay, now significant entities. They have said that the Competition Commission of India will create a you can say particular class that is called systematically significant digital enterprises. Systematically significant digital enterprises, SSDEs. Now who will decide that? That Competition Commission of India will decide on that. There are certain parameters. Okay, these parameters are that last three financial years the turnover in India should not be less than 4,000 crores. Okay, or the global turnover should not be less than 30 billion. The gross merchandise value should not be less than 60,000 crores. Global market capitalization should not be less than $75 billion. Okay, so these are certain things. You don't have to remember all these things. Just know that there are certain parameters on which Competition Commission of India will decide that which particular entity is systematically significant digital enterprises. Here with this term systematically significant, here you can say that these companies are too big to fail. These companies are too big. If they are not regulated, they can take the undue advantage of the market. Okay, so that is why they have decided this systematically significant digital enterprises. Okay, now CCI will have discretionary power. Discretionary power, why? Even if some company is there which is having a presence in the global market, but the thing is that company is not following these particular parameters, in that case also if Competition Commission of India wants, they can go for you can say designating that company as a SSDE. Okay, so that is about this particular significant entities. Then there is this another thing that is associated digital enterprises. Now as I told you, if you are going for the Google search, they will give you some results, and then you will find that there are Google related, Gmail related, or you can say Google Maps related, YouTube related answers will be at the top. Okay, so these are basically what is happening is that Google, by their search engines or the other data which they are using that data for other you can say applications as well, like that is YouTube, or you can say Gmail, etc. So basically what they are doing is they are using the data for other smaller companies as well. Okay, so that is basically your associate digital enterprises. Here you can say understanding the role that data collected by one company of a major technology group can play in benefiting the other group companies. Okay, so there will be a data which has been collected by a major company, and that will be used for the benefiting the other small companies they own. Okay, so that is the associated digital enterprises. Now ADEs would have the same obligation as SSDs. Okay, similar obligations should be there on them, depending on the level of their involvement with the core digital service offered by the main company. Now, when we are talking about this example over here, Google Maps or the YouTube can be the best example over here, because here Google will be the ADEs. When we are talking about associate digital enterprises, Google will be the ADE, because Google is collecting the data and that can be utilized for the YouTube as well. So that these are ADEs. Okay. Now, when we are talking about these SSDEs, they will have a significant presence. Second thing is, they will be prohibited from the engaging in the practices which we have already talked about, that you cannot go for the unfair competition, you cannot go for influencing certain things, you cannot go for the preferencing your own products. Such things will be, or such obligation will be placed on the SSADs. Okay, so practices like self-preferencing, anti-steering. What is anti-steering? I'll tell you. Then restricting the third party applications. So all such things you will not be able to do, and then if you are doing it, then you will be fined up to 10% of the global turnover. Okay, so that is about this particular thing. Now, criticism from the big companies. Now just think about it, what kind of you can say issue these big companies will have. First of all, they are saying that we are trying to regulate you now. Now this overall is issue for the big companies, that now there will be a regulation for that. Second thing is, they are saying that there will be a predictive regulation, predictive or presumptive regulation. So because of which there are certain activities which can be restricted. Now when we are talking about the big firms, okay, they are going for the research and development. There are, in the meanwhile, in the research and development, there are various arenas which are explored. Okay, now they are saying that there are certain things you cannot do. Okay, beforehand you cannot do, before they have started doing it, they are saying that you cannot do it. Now in the course of the R&D, these things will happen, and then they cannot capitalize it. Okay, so that is one you can say obligation, or you can say one criticism of this particular act. They are saying that you are going for the presumptive regulation that will harm the you can say companies, or you can say big tech techs. Okay, so here you can say, for big tech, an ex ante framework, that is presumptive framework with strict prescriptive norms, could lead to a significant company burden. Okay, so here compliance burden will be there. So that is one thing. Shift focus from innovation and research to ensuring that companies do not presumptively engage in anti-competitive practices. Again, from the R&D, they will have a focus on this particular thing, that we are not doing anything which is banned from the government side. Okay. Then calling for the current competition law to be strengthened. Now basically what they are saying is that you don't have to go for a new law, there is already a competition act. Okay, you can strengthen that. Okay, so that is basically said by the big companies over here. Now stringent requirement of the European Union's Digital Markets Act, there is this particular act, DMAs in European Union, an increase of 400 times. Basically when we are talking about the any kind of service which has been provided, there is in the European Union, there is this act, that is Digital Markets Act, and because of which there are certain stringent provisions which are present in the Digital Marketing Act of the European Union, and it was seen that after that provisions has been followed, there has been an increase of 4,000% in the time it takes to find out, or you can say come up with the results. Okay, so after such stringent provisions, if you are going for a Google search, that time it took has increased by the 400%. Okay, so that is what companies are saying, that since in European Union something like that has happened, similar things can happen in India as well. Okay, so ultimately there will be a latency, or you can say there will be a less efficiency. It will impact the efficiency of the working of such companies. Now potentially security ramification will be there, because they are saying that you cannot stop any third party from doing anything like that, because they have said that you cannot go for the activities like the self-preferencing and anti-steering. I'll tell you what is anti-steering first. Here you can see, when we are talking about the self-preferencing, it is a term that describes a platform favoring its own product and services over those the third parties. Okay, so let's say there is this company, for example, there is some company called Myntra. Okay, in Myntra there is a brand that is Roadster. Now this Roadster brand is from Myntra itself, and when you go for a search, if Roadster comes at the top and other brands come at bottom, that will be self-preferencing. Again, I'm not saying that Myntra does that, I'm saying that if something like that happens, that in that case there will be self-preferencing. Okay, so that is an example, or you can say this is for the better understanding. Here let's say that there is this A company, it has a brand, that is brand X. Okay, Now in that particular brand, if you are going for the search for any kind of, let's say, cargo pants on this particular company's website, and they are showing a cargo pant from this brand X, so ultimately that will be a self-preferencing. Okay. Other than that, anti-steering, this will also have a similar definition. Here you can say anti-steering provisions are clauses wherein a platform prevents its business users from steering its customer to offer other than those provided by the platform. So basically, steering means that when we are talking about the cars etc., we have a steering wheels, that is basically guiding wheel with or you can say the direction will be changed by that. Now anti-steering means that will prohibit it the companies from steering the crowd to a particular direction. Okay. So here you can say anti-steering provision are the clause wherein a platform prevents its business users from steering its customers to offer other than those provided by the platform. Okay. So that is basically, if there is a platform and there are certain 20 brands and 5 of them are from the platform itself, then there will be a anti-steering mechanism wherein those other customer or those other brands will not be preferred. Okay. So that is basically your anti-steering. So such things cannot be done by these companies, and since you are not doing it, that means that there will be a third party which also get benefits from your platform. So that is why they have concern with that as well, the potential security ramification allowing the third party downloads. Other than that, there was one more thing which has been said that, let's say they are saying that self-preferencing is not allowed. You have this brand that is Apple. Now Apple has their own interface, Apple has their own store. Now you are saying that self-steering is self-preference is not allowed. That means that on that particular Apple cannot do something like that, having their own store. Okay. So what will happen is that there will be a Play Store on which Apple will put their own products as well, or they will allow the Play Store as well. That means that Google has to allow Apple to at that particular arena, or I'm not saying that Google has to do it, or you can say Apple has to allow Google, something like that. There will be a common platform on which all the services, all the applications will be there. Ultimately third parties are entering into your domain over there, so that will have a security ramification. Okay. Now in this particular act, there are certain broad definition has been used, or you can say open-ended definitions has been used, so that can be detrimental for the companies. Here let's say they have said that quantitative and the qualitative parameters are there, which we have already talked about here. These parameters are there on the basis of which they will decide which company is the significant over here, systematically significant company. So they are saying that is the discretion of CCI, and Competition Commission of India might misuse this particular discretion. Okay. So that is about the concern which has been raised by the companies. Then need for the digital competition. So why we have this need for this particular bill? Because since the technology is moving so fast. Second thing is, as I told you, there are, you can say, big companies which can go for, which has the history of such things. Like you must have heard that Google was fined by CCI for like 1,337 crore. So such things has happened in the past. So that is why we are thinking that there should be a act which can you can say restrict the these activities which are unduly influencing the market. Okay, hold on. So that is the need of these Competition Act. Okay, for instance, you can take first we will say official believes that this is due to the high market barriers for the new entrants to the sector. So there are certain time what you will see that there are companies which are taking over the whole sector. Okay, because they have entered into it first. Let's say when we are talking about the Meta has Facebook has entered into it first, and then afterwards there was this WhatsApp etc. Now there are very less new entries or new startups which can make a place for themselves. Okay, now when we are talking about the WhatsApp is a messenger which has become a norm. Everyone is using WhatsApp, everyone is hoping that everyone will have WhatsApp. Now if you are going for the security concern, there is another app, that is Signal. That Signal app is as good as WhatsApp, even more secure than WhatsApp, but again WhatsApp has acquired the market. Okay, so after that any new player might not be able to enter into it. Okay, so there is this undue competition which has happened. So for such things, such laws are necessary. Okay, this example, same example is given over here, so I don't have to remember repeat that. So I hope this is clear. Now we can move to the next article. So placing new era in ties, Putin and Xi tells US abandon Cold War mentality. Okay, so basically after the swearing ceremony of the president of Russia, he has won the election and now he has sworn in as the president for the next term. He has gone for the first visit to China. Okay, so that tells that how their strategic you can say relations are improving. Okay, or they are trying to make a partnership that is against, you can say, USA. Here you can see US puts security of narrow groups above the regional stability, says the joint statement. Now China's Xi Jinping and Russia's Vladimir Putin Thursday pledged a new era of partnership between the two most powerful rivals of USA, which they cast as an aggressive Cold War hegemon that was showing chaos around the world. Okay, so basically saying that they are saying that USA still has the Cold War mentality and they have to actually let it go, and that is why they have come up with the new era of partnership. And China and Russia declared no limit partnership in 2022 February. They have done, just few days before Russia has gone for the Ukraine attack. So that has happened, that is no limit partnership, and now they have gone for the new era of partnership. Okay, now in the joint statement they have said that about the new era that proclaimed the opposition to USA on a host of services host of the security issues and shared view on everything from Taiwan, Ukraine to North Korea, and cooperation on the peaceful nuclear technology, etc. So basically these are the area of you can say partnership on which they are focusing, and basically this is an alliance, or you can say this is a partnership which is targeting USA, and they are openly saying that too. Okay, Putin's visit come weeks after the US Secretary General of the State Anthony Blinken flew to China and raised concern over the what he said was China's support for the Russian military. Okay, so they raised concern, and recently you know that there was this economic sanctions, or you can say there was duty which has been increased. All these things has happened. They will lead into a new trade war between USA and China. Okay, so that is a cause of concern here. Now here the United States still thinks in the terms of the Cold War. It guided by the logic of bloc confrontation, putting the security of the narrow groups above the regional security. So basically they are saying that USA is working on their own interest rather than the regional security, and because of which the regional security will go through certain chaos, and they have actually gone for the partnership to secure the region. Okay, so here thus the USA must abandon this behavior. It condemns the initiative to seize assets and the properties of the foreign states, a clear reference to the Western move to redirect the profits from the frozen Russian assets to the assets which they are using to you can say send aid in the Ukraine war. So basically they are saying that here in this particular case they are saying that the Western countries like USA and other Western countries, what they have started doing is that they have seized the Russian assets in their countries, and they are selling it, and whatever profit they are getting out of it, they are using it to send money to the Ukraine. Okay, so all these things has been discussed over here, sending a message by picking China for its first foreign trip since the sworn-in ceremony from the last month. Putin is sending a message to the world about his priorities and strength of his personal ties with Xi. So basically here we are saying that China and Russia, they are basically coming closer, and they are partnering around a particular enemy, that is basically a particular rival, that is USA. Okay, so I hope this is clear. And now moving further, the tariff war between USA may trigger dumping Chinese products. So earlier we have discussed that USA has gone for the sanctions on various imports from China, that is electric vehicle, batteries, computer chips, medical products. Okay, so all these things has happened. Now China is saying that they will retaliate, and ultimately we are saying that there can be two things which how it will impact India. Okay, one thing is that we can get benefit out of it. What benefit? The thing is USA is saying that they will not take imports from China. Okay, so obviously USA's demand can be fulfilled by India or any other countries as well. Okay, so when we are talking about something about chips, okay, we are going for the chip manufacturing, etc. So for the chips or the, you can say, medical devices, PPE kits, etc., for that India can take advantage of this particular thing, and India can export these things to USA. Okay, so that is the one thing, that is the advantage which we can take. Second thing here is that we can have a disadvantage. What is the disadvantage over here is that China is sending a lot of products to USA. So USA was a market for China. Okay, USA was a market for China. Now USA is saying that we will not take it from you. Okay, similarly Western countries like UK, etc., or you can say European Union, European Commission is there. So they are also saying that they are also scrutinizing, or they are also seeing whether such products has been made by any kind of, you can say, subsidy which has been given to the producers in the China, and because of which these prices are low. And if these prices are low because of any undue advantage which China is giving to their producers, and because of which if they are going for the cheap products, so in that case they will not go for the taking these products from China. Okay, so ultimately what they are saying that USA and European Union, etc., are saying that they will curtail the imports from China. So ultimately China's market will be decreasing. But China is sitting on a huge, you can say, inventory, because in the last few years we have seen that China has gone for the manufacturing, but domestic demand is very low. Okay, and because of certain other factors, global factors as well, the China's economy was going through a slowdown. Ultimately China has to ramp up from this particular phenomena by doing by going for an export based you can say growth. So when USA and EU, these are the big markets for China, and they are saying that they will not take the, you can say, these exports from China. So ultimately China has to find another market, and that market will be India. And if that market is India, then you will see that India will be having a lot of dump coming from China. These cheap products from China, they will come and flood Indian market and ultimately harm the domestic markets of India. Okay, so for that government has to be very cautious. So that is what has been discussed in this article, that one benefit is that because USA is not taking products from China, you can go for the fulfilling that particular void and the gap. And second thing is that now since that market of USA and Europe is being closed for China, China will go for dumping these products in India. Government has to be very cautious about that. Okay, so these are the two things, these are the two impacts of the tariff war between USA and China. Okay, now moving further, for your own read, there is this article, Xi, Putin and the world. So this is mains oriented article, so I have not discussed it for now. So if you have this time, you can go through it, otherwise save it for later. Okay, so that is about this article. Now last part, that is basically your practice question. Okay, so there is this comment, due process again. So basically when we are talking about the procedure established by law, procedure established by law means that there should be a law which is giving government or the executive an authority to perform certain function. Okay, so let's say when we are talking about acquisition of property, let's say, okay, so there is this particular law which says that government can acquire any property, okay, for public purpose. So that is the procedure established by law. There is a procedure which has been now there are certain 5, 6, 7 points which are given, that by this particular steps you can go for the acquisition of particular thing. That is procedure established by law. Now law has made a procedure and government has to follow this particular procedure. Okay, now when we are talking about the due course, in the due course we will say, or due process we will see that whether this particular process has been followed or not, whether this process is right or not. Okay, so when we are talking about the due process, we will look into the rationality, we will look into the you can say how this particular process was followed, if there is anything which has been done wrongly. Okay, so that will be the due process. And when we are talking about procedure established by law, there can be a procedure which government has established and that has to be followed, and how it has been followed or not, that is the one thing. Second thing, if for other example, if we see, let's say when we are talking about India, we have a form of punishment, that is capital punishment. Okay, in very rare cases we go for the capital punishment. Okay, so Article 21 says that you can say there is this provision, the government can or you can say state cannot take life of a person or the life or liberty of the person other than except for the procedure established by law. Okay, so means that if there is a law which provides that you can take a life, then you can take a life. Okay, so we have in Indian Penal Code we have a procedure, we have a provision which says that in certain cases you can go for the death penalty. Okay, so that is one thing. Now when we are talking about the due process, we will see whether such thing is rationally right or not. Okay, so generally in the constitution procedure established by law is given, and when we are talking about due process, Supreme Court's interpretation say that we are a nation which is following due process. Even US is following due process. Okay, so we are having a mix of procedure established by law and due process. So ultimately this is just a procedure which has been established or by the law, or you can say this is the letter of the law, this is the spirit of the law. Okay, I hope this is clear. Now your practice question. Which of the following bodies of the water separates Kachativu Islands from mainland India? Okay, so Kachativu Island has been in news, which we have discussed in our news analysis and other than our current affairs as well. So here you can see Gulf of Mannar, Gulf of Kutch, Park Strait and Andaman Sea. So you have to choose the correct answer and reply in the comment box. With that, I would like to take your leave, and if you have not subscribed the channel, please subscribe the channel. Thank you. Have a good day.